Thank you.
Thank you.
Okay, that one's concluded. The last and final case is Department of Highway Safety versus COMBEE. Okay. You got 20 minutes.
Good morning. May it please the Court, my name is Richard Kahn. I represent the Department of Highway Safety and Motor Vehicles. This case is an appeal of a Circuit Court order granting summary judgment for the appellee. In its order, the Circuit Court ordered the Department to reinstate the appellee's driving privileges. The Department seeks a reversal of that order. The facts of this case are generally, the basic essential facts of this case are undisputed. The appellee has been convicted 6 times of the offense of DUI in the state of Florida, with the last offense occurring in 1984. Pursuant to Section 322.282.
I'm trying to find out when he got the second license.
And how?
I don't know that that's fully in the record. We initially believed that he obtained the second license by fraud. I don't know that our
Well, the
department...
trial court said there's no fraud here,
Right.
so...
I don't know that we were ultimately able to show that certainly at the trial court. And the trial court found there was no fraud. Certainly one of my positions would be that even taking the fraud issue, or question out of the picture, the fact is the defendant had 2 records. When they were combined, he has 6 DUIs. The last one occurred in 1984. The statute says that for someone who has
So even if it was the department's negligence that resulted in the 2 records, it doesn't matter?
Our position would be it would not matter, because ultimately this is the same individual who has 6 DUIs, the last one occurring after July 1st, 1982.
Okay, so what's the difference in time between the 2 driver's license and then they come back together, or the department?
The 2 driver's licenses exist at some point in the late 70s. The first driver's license contained 5 convictions for DUI and was in the name of Gene H. Combee. The second driver's license was obtained in the name of Horace Eugene Combee, with the first and middle name switched and Gene changed to Eugene. The second driver's license only reflects the 1 DUI. And that DUI was obtained in 1984. The other record contained 5. The statute was amended.
Okay, so from 1984 until when?
I'm sorry? He operated under the 1984, that 1984 license with that conviction, the Horace Eugene Combee license was the one he continued to operate under up until 2007. My understanding is the original Gene H. Combee license has been sitting kind of dormant.
It had the 5 DUI. 23 years.
Yes. Upon being notified of the conviction, the defendant pled and was convicted of a first DUI in 1984. That was what was put on his record. The department suspended it for 1 year in accordance with the first DUI conviction. In 1988, the defendant reinstated his driving privilege under the name of Horace Eugene Combee. The department discovered in 2004 that there were 2 driving records. Changes in technology, certainly things changing after September 11th. The department's...
Was his second driver's license issued at the time that his first driver's license was under suspension? Because I understand in the 77 conviction, I think the statute back then said if it's more than 3 convictions, from 1 to 5 years, and I think it was suspended for 2 years, wasn't it?
Judge, I believe it would have been suspended. Actually, his final conviction...
So when he obtained his second driver's license, was his first driver's license still under suspension?
My understanding is that would be correct. I don't know that the record fully details all these dates going back that far, but
you don't
my
really
understanding
know
would be
when
yes.
the second one was issued, do you?
I don't have a record of when the second one was issued.
Well, it had to have been before 84.
Oh, it was definitely before 84. My understanding is it was sometime in 1970 or 9. Unfortunately, the records that the department kept back then are a little spotty. not the greatest. We're dealing with paper records, certainly before the age of computers. When the department discovered that there were 2 licenses, they at first suspected fraud, investigated that. Ultimately, the 2 license records were combined into 1, and the department imposed a permanent revocation of his driving privilege. The summary judgment that was entered by the trial court did make a finding that no fraud was presented, or there was no proof of fraud on behalf of the appellee, and applied the doctrine of equitable estoppel to prohibit the department from suspending his license. The ordered the department to reinstate the license effective as of October 6, 2006 for a term of 6 years. The department's position is the circuit court erred in ordering the department to issue a driver's license to the appellee where his license remains under a permanent suspension by Florida law for his 6 DUI convictions. Section 322.282E, Florida statute, requires and mandates the permanent suspension of anyone who has been convicted of 4 or more DUIs where the last one occurs after July 1st, 1982. That's exactly what occurs in this case. The last conviction was in 1984, and it was the 6th. The appellee, accordingly, under that section of the statute, his license is under a permanent revocation at this time and has been since 1984 when he was in fact convicted.
How did it get renewed 2 times in the interim?
It was, again, we were talking about the renewal of the license that reflected only 1 DUI conviction. The department at the time of those renewals did not know that that was in fact, there were 2 records and it was the 6th rather than the 1st. It did take us...
It was renewed after it was permanently revoked in 2004?
No, I don't believe it was renewed after being revoked. Again, I think the fact that we initially treated it as a fraud case, you can put that aside. The ultimate issue still remains the appellee has 6 DUI convictions, and under the statute, he's not entitled, he's under a permanent revocation. Plain language, neither department nor the courts have discretion with regarding this revocation. The statute mandates that it takes effect automatically upon a conviction for a 4th DUI after that.
What was the law relating to hardship licenses back in...
The law has changed.
Back in the 77 to 84 period, did the law change any then?
I don't know that the law has changed on hardship licenses a couple of times. There's actually been a period of time where it was permitted, it was taken away, and then it came back for a window of time, and then it's been prohibited yet again.
So they're prohibited now?
They are prohibited at the moment.
Were they prohibited at the time that his license was revoked in 84? Or were they
I believe in 84 they were. I think
prohibited in 84?
I think that subsequent to that there was a period of time where they allowed you to get a hardship license.
What does that mean, they allowed? Is there a statute that says that, or is there a...
It's in the statute, and there is a provision where someone can go down, they petition for the issuance of...
What's the statute number?
I think that's 322.2816.
Okay, and so you petition, and then it's up to the department whether they give it to you or not?
Yeah, you petition, the hearing is held, and if the driver can show that they haven't driven, I believe, for 5 years, the preceding 5 years, and otherwise have not been convicted of another DUI offense, they recommend them for it. They enroll in a special DUI supervision school. It's part of the condition of having the hardship license. As long as they remain in the school and under supervision, a hardship license can be issued to them.
Is it mandated that it be issued, or is it just discretionary?
It's discretionary.
Okay, but you're saying the law has changed now that there's no hardship licenses anymore. Since
That's correct.
When? You know since when? If you don't.
I believe the law went into effect in 2006. Was when there was a period of time where, due to I believe a single subject violation, the law was declared invalid, and then it was ultimately readopted.
Well, if you suspended his license kind of non-pro-tunc back to 1984, would he still be able to apply then, if we go back to 84, to a hardship license where they were permitted at that time?
Currently, the present state of the law, as I understand it, is but you get the hardship license at the date of applying for it, not the date of the offense.
I'm asking you what law would apply. Would it be the 84? Because you suspended it non-pro-tunc back to 84, essentially. So if that's the case, wouldn't we go back to 84 and say, well, if that's the case, then he maybe would be entitled under the 84 law rather than the current law?
My position would be no. Actually, I think the statute is clear that the hardship license is from the date it's applied for, not the date of the suspension. The Circuit Court did apply the doctrine of equitable estoppel. Equitable estoppel, for purposes of this case, does have the 3 elements of representation by the state, a reasonable reliance on that representation, and a change in position detrimental by the person relying on the representation. Our position is that the appellee fails to satisfy two of these elements. When the appellee was sentenced for DUI in 1984, he pled and took penalties for a first DUI. He knew very well at the time that was not his first DUI. He didn't challenge that. He didn't speak up about it. He was hoping that the record wouldn't catch up with him. And so my position would be his reliance on being told that that was a first-time DUI penalty and that he could get his license back was not reasonable. He knew it was, in fact, not his first DUI. The second one being the issue of showing some kind of detrimental change in position. I don't think the...
Is that in the record, that he knew that it wasn't his first DUI?
Well, certainly the defendant has been convicted 6 times of DUI. I think that's certainly an inference that he knows of each time he's been convicted of it.
But you're basing it on, there was no testimony.
There's no testimony to show that he, in fact, had personal knowledge of each of those 6 DUIs, no. But they're not disputing that he has 6. I mean, that's a fact that's not in dispute, is my understanding.
I understand. Thank you.
Really, all you need to do is introduce a certified copy of the driver's license record, and there's a presumption that, you know, that he received it and that he knows the contents of it, and that's all that the state needs to prove, unless the presumption therefore becomes rebuttable, right?
Yes, Judge.
All right.
Second argument we say is detrimental change in position. The defendant, argues that completing a driving training course and a substance abuse counseling constitutes a detrimental or harm to him. I would submit that that's not the case. In fact, completing those 2 things allowed him to obtain a driver's license and drive for 20 years. He got a benefit out of those things. I don't see that as a harm under the equitable estoppel theory. Finally, certainly in the case of Bronco versus City of Miramar and some of the other cases cited in the brief, I would argue that equitable estoppel doesn't even apply in the instant case, and that it's basically forcing the state to it's entering an order that forces accomplishing a legal result. The statute says a person with 4 DUIs is issued a permanent revocation of their license. We are being told to issue that personal license in direct contravention of the statute. The department has the authority to cancel a driver's license upon determining that the licensee is not entitled to the issuance thereof. Our position is that the circuit court's order requiring us, directing the department to issue the license is a direct contravention of Florida law. It's uncontroverted that the appellee has 6 DUIs and that these DUIs would constitute a permanent revocation under the statute. The fact that the department erroneously licensed the appellee from 1984 to 2007 doesn't change the fact that he's got 4 more DUIs, the last of which occurred in 1984, and thus is statutorily barred from obtaining a driver's license. How did you license him through 2007 if you just told us that you suspended his license permanently in 2004? 2004 was when it was discovered. I believe the actual suspension may defer to the brief on the exact timing of this. I think it was discovered in 2004. It was in 2007. I think that's when the official notice was sent and it was taken care of. Again, it was investigated first for fraud, and then that notice was sent, and I think rescinded, and another one was sent later. It's been a little bit of a process in the way they went about it. Basically, we're asking that the court correct the circuit court's error by quashing the order of the circuit court requiring us to reissue the license.
Okay.
Good morning. May it please the court. Anderson Hatfield for the appellee, Mr. Combee. I'm from Gainesville, Florida. I think there's a real misconception on the part of the Department of Motor Vehicles in this case about what the facts are. The fact that Mr. Combee has 6 convictions, the fact that his license, that he's not entitled to a license under 322.28 is not self-executing, and that's a very important point in this case, because in 1984, when Mr. Combee went before the Orange County Court, what the county judge did was suspend his license for life, which was not permitted by the statute. Then the department took
where is that in the record?
I believe that's in the deposition of Dana Reading, Your Honor.
Is it deposition of who?
Dana Reading, and we did attach, I believe.
So when he appeared in 84, the trial judge must have had a copy of his other driving record in order to make that suspension.
Yes, sir.
All right. So his license was suspended in 84 for life.
Yes, sir. The DMV apparently realized that that was an incorrect suspension, and in January of 1985 issued an order that his license was suspended or revoked for 1 year for the DUI conviction.
Well, we've established that in '84 it was correctly suspended for life then.
No, sir. The judge had no authority to suspend it for life. He could only permanently revoke his license.
Okay, he permanently revoked his license in
No, sir,
'84.
he did not permanently revoke his
He
license.
just told me in '84 he did.
No, sir. He revoked his license for life. That's exactly
Okay,
what the judge wrote in the order.
For life? Okay.
Yes, sir.
All right, so
The judge wrote in the order,
that was a correct ruling then, wasn't it?
no, sir. The
Why-
statute did not permit that the license be revoked for life. It only permitted that the license be permanently revoked.
What's the difference between the two?
Well, the two is, if you had...
I mean, when you
well,
die,
the difference
that's
is
it.
this.
I mean, it's a permanent revocation is for the rest of your life. So, I mean, are we talking about semantics here?
Judge, no, sir, I think you already covered that in your question about, to him, he could have reapplied for a license back in 1984 after 10 years. And the statute did not permit revocation for life. The statute has to be strictly construed, and the statute said you could only revoke the license permanently, meaning that it can be restored at some later point. If the statute
Permanently revoked means it cannot be restored at some later time.
In 1984, it meant that it could.
Oh, it could. All right, but if it was permanently revoked, if it was revoked for life, then it couldn't.
Judge, it could not be revoked for life because the statute did not allow a judge to revoke the license for life.
Well, isn't that really what the judge meant then? I mean, when he revoked it for life, that he was permanently revoking it.
I don't know, Judge. I
Yeah,
wasn't representing anybody in that
We're
case.
talking about semantics here, aren't we?
No, sir, I don't think so. I think it's a very important legal point.
And
that is in the
so
statute.
if I say that was a correct ruling, that there's really no difference between permanently revoked or revoked for life, then that if there's no difference between the two, then a correct decision was made at that point, based on his actual driving record.
Yes, sir, but
And then the
I
department
don't believe that's the law. I mean, the statute did not give anybody.
Well, if that was
authority.
the case, then the department would have no legal way to reissue him a license because the statute says the court must do it. It's mandatory for the court to do it.
No, sir, I believe what the statute says, that if the
The court
judge...
shall permanently revoke the driver's license if the person has been convicted 4 times. And the court has to do it. I'm saying the court has to do it. If the court does it, then the department can't come back and undo it. The court order, can it?
But if you read on, yes, it can, because if you read on...
The point I'm getting at is, if that's the case, and we're talking about estoppel here, how does estoppel even apply now? If now we've learned that it was revoked for life, but then you say, well, that was illegal because it's supposed to be permanently revoked, and I'm having a difficult time distinguishing between the two, where does estoppel come in?
It goes to the 1985 order that was issued by the DMV, Your Honor, because if you'll read on under 328, it says the court will permanently revoke the license, and if it says if the court fails to do that, then the department will permanently revoke the license. And that's exactly the point I'm trying to make about that statute. It's not self-executing. So when we appeared before the circuit judge over in DeLand, and it's admitted by the department in this case, this license, 325, and I distinguish these two licenses by the only numbers that are different.
288 and 325.
288 and 325. The license 325 has never been revoked by the Department of Motor Vehicles. And when that judge told the Department of Motor Vehicles to give him his license back, the court was not committing an illegal act.
Why isn't that in order to perform an illegal act? Because the trial judge had already revoked it for life. And now a trial judge is saying, well, now department, you got to give him his license back. That's an illegal act, isn't it?
No, sir. I think I can go back and answer that again when we go back and read with specificity the statute 32228 when it says that after 4, then the license can be revoked permanently by the court.
No, it says can, it says shall.
Shall.
You have to do it.
Exactly. And it says failing that, then the department enters the revocation. The judge did not revoke the license permanently, Your Honor. I have to go back to that point.
I know, you're just saying he revoked it for life.
He revoked it for life.
I don't know what the difference is.
Then if you read that statute, it was incumbent then upon the DMV to enter the permanent revocation. And what they did is they entered...
Are there cases out there that say that if you revoke it for life as opposed to permanently revoke, that's an illegal sentence?
There probably is, because I think it's a strict construction of the statute, and unfortunately, Your Honor, I'm not prepared to address you with those cases, but I'll be happy to.
Maybe you can help me with the estoppel aspect of it, because I'm having
Your
trouble
Honor, the other thing about it is they never argued that in this case.
Argued what?
They never argued that in 1984 the license was properly revoked. That's contrary to what the DMV is trying to do here. In 2007, they enter an order trying to correct that situation. The DMV knows this license was never properly revoked. And Dana Reading...
Where is there a time limit in the statute that cuts DMV off from permanently revoking a driver's license that should have been revoked sometime? There's no time limit for that, is there?
Your Honor, honestly, I think today he could go back to the DMV office and tell them to cut an order permanently revoking the license, but then we would be back in here arguing the same thing, which is the equitable estoppel and administrative finality.
How does equitable estoppel apply when you have to show detriment? Where's the detriment when opposing counsel argues that the detriment is that he essentially got another license for 20-some years and essentially got a free ride for 20-some years, as opposed to, well, he could have applied for a hardship license, and that's discretionary. We don't know if he'd applied whether he actually got one or not.
I think the enjoyment...
Where's the detriment there?
I think the enjoyment of a driver's license, Your Honor, like any other thing in life, has a prospective part to it. It's all prospective. So if this court reverses the order of the judge and takes his license, then he cannot ever obtain a license under the current law unless it's changed again. And he went through...
You don't know whether he would have obtained a hardship license anyway had he applied for it. But now, I mean, you're saying that he relied on this to his detriment. I have a hard time with the reliance aspect of it, too, because the detriment is he got a free ride for 20-some years because he got a license, a full-blown license for 20-some years. And that's a detriment to him.
It wasn't a question. If it pleases the court, it wasn't a question of a hardship license, because during that respite in 1991 up until 1997, he could have had a full license, because the law was, and the execution of 322.28 is found in 322.271, and the execution was, at that point, after 10 years, then he could have applied to have his license reinstated, irrespective of any hardship clause.
Well, okay, go ahead.
You're saying in 1984, the concept of a permanent revocation was he was allowed to get another license in 10 years?
Yes, Your Honor. And so in 1994, he could have applied for a full license. Then the law changed again, and then later he could have applied for a hardship license. The law has changed for a third or fourth time now, and he can't get any license. And it's like I said, the detriment is it's prospective. The use of a license, if you don't have it from this day forward, is a substantial loss in life. It's a loss of enjoyment of the beach. It's a loss of going places with your family. It's a loss of pursuing an opportunity for an employment someplace that you may not otherwise have. And, Your Honor, the other proposition is it did not call for this judge to do an illegal act, and I cannot stress this enough, and there's nothing in this court's order that was an illegal act.
I have a hard time with that, because I have a hard time, number one, distinguishing between a permanent revocation and revocation for life. It seems to me that they're the same thing. And if that was actually done back in 1984, then for the trial judge to tell the department now in 2007 or 2008 or whenever it was, give him his license back when the statute says, and no driver's license or driving privilege may be issued or granted to any such person. That's what the statute says. And so the trial judge is saying, department, despite that language, give it back to him anyway.
Your Honor, can I suggest what the trial judge said? The trial judge said, give him back his license that you already gave him back in 1988. And I think earlier the court had a question about when he actually obtained the license. He obtained reinstatement of the license in September of 1988. That license was renewed in 1994 at the regular 6-year interval. It was renewed in 2000 at the regular 6-month interval. So when the judge is saying it should have renewed in 2006, that would have been the regular interval there also. So the judge, in the final judgment in this case, it does not cite to an order of the Department of Motor Vehicles that the judge is saying is illegal. The judge does not try to modify an order of the Department of Motor Vehicles in any respect. The judge is saying...
I'm having a hard time, I'll be honest with you, I'm having a hard time with the fact that his license was revoked for life back in 1984. Then, and the statute says that it's got to be permanently revoked, and the court has to do it. The court doesn't do it in 30 days because the court loses jurisdiction after 30 days, and the department has to do it. And there's no time limit for the department to do it. They can do it 5 years later, 10 years later, it seems to me, if they want to. But then for the trial judge to come back and say, well, because the department screwed up, I'm going to require that the department get him his license back in contravention of the clear meaning of the statute says, no driver's license or driving privilege may be issued or granted to any such person. And that's exactly what the trial judge did in this case.
Your Honor, the department didn't take his license.
The trial judge did. And the department had no legal basis to come back and reissue it to him.
No, sir. The department did not take his license, and they never have taken his license since 1988.
Trial court did. The trial court did in 84, according to what you're telling me. The trial court took his license and for life. Now you're saying that's different than permanent revocation. I mean, I have a hard time with that. But.
Judge, I think there is case law on that, and I would not say that if I did not have that.
I believe you when you
and I apologize to the court for not having that case law. And the reason I am confident that that would be the law anyway is it is absolutely logical. The judge had no authority to say revocation for life. Now, because it wasn't in the statute. That means that he could never, if the court upheld that and said, okay, you down in Orange County, you're a judge that can say there's a resident of Florida that can never have a license.
How can you say that if he revokes it for life, that there's no authority for him getting a hardship license, when, according to your own argument, revocation for life is an illegal revocation, and so, where does the argument come in that, well, he couldn't get a hardship license then? I mean, I'm having a hard time following that too.
Okay, well, I think I can explain that, Your Honor.
Okay.
Let's proposition that the judge makes an illegal revocation and says it's for life. Now, Mr. Combee wants to...
No, I mean, my point is that the permanent revocation for life, and you say there's no such thing.
Right.
So how do you know that he couldn't get a hardship permit even if it was revoked for life, if there's no such thing?
I think he could have gotten a hardship permit.
And has been revoked for life.
Right. Because the state...
Why didn't he apply for one then?
Well, the time wasn't up. It would have been the 10-year period, Your Honor. Mm-hmm. In other words, if he'd have walked into the circuit court on a declaratory judgment in 1994 and said, I want my license back, and DMV won't give me my license. I have my license last suspect. Well, they won't give me a hearing. That would have been the issue. The DMV would have said, we're not going to give you a hearing because you're suspended for life. And then he goes to circuit court and he says, DMV won't give me a hearing because they said I'm suspended for life. That's an illegal order. I want a hearing. And at that time, the 10-year period would have been up, and the circuit court would have been obligated to say that it was an illegal fine.
Is there a copy of, you're saying that the record shows that the trial judge suspended it for, revoked it for life? Is there a copy of that? How do you know that? I mean, where is that in the record?
It may have been attached to my complaint or pled in my complaint, and I'm not sure, Your Honor.
Okay.
But I mean, I've seen it. I don't think
the
anybody...
deposition establishes it too, the deposition of Ms. Redding or whatever her name was from the department?
I don't think it was, because that never was an issue, Judge. Honestly. I think I probably did plead it in the complaint that it was an illegal order, suspension for life. And unfortunately, I didn't go back to review the complaint. I'll see it run low on time. But the point is, I think what DMV misses here is, this is not a self-executing proposition when somebody has 4 or more DUIs. In other words, if the judge doesn't properly suspend it and the DMV comes back and says, well, we're going to suspend it, under 322.251, they have to do that in a specific way. They have to send the notice to the last address that they have on their records. In 2007, then, when they attempt to correct this order of January of 1985, 22 years earlier, they send it to an address in Orlando, Florida. They have this correct address, street address, on it, but not DeLand, Florida, but Orlando, Florida. So Ms. Redding, in her deposition, she admits that this license 325 has never been suspended. I mean, I don't think I could have better evidence of that.
She said the department never suspended it. She said the department never suspended it.
No, sir, I think she says it's never been suspended, because I think if I had asked Ms. Redding that question, can you suspend a license for life, her answer would be, no, you cannot. I'm confident that would be her answer.
Can I ask 2 questions?
Yes, sir.
Back to 1984, the 10-year period of time, is that to apply for a hardship license?
No, Your Honor, that would be to apply for a plenary license.
Full license?
Full
and
license.
In 1984, when the judge suspended it using the language that he used, then what did DMV do?
6 months later, or 3 months later, they issued an order that suspended his license for 1 year, revoked his license for 1 year, citing that DUI conviction. And that order is attached in Dana Redding's deposition, and there's no question about the authenticity of that order or anything either.
Okay, you've got 20 seconds left, so.
I was just going to comment on the preceding argument. I found very interesting on the authentication of documents on the motion for summary judgment, because in this case, that was, if you'll notice in my brief, that was one of the points that I had made, that DMV did not argue this case at all, because
I know they just came in and said, we're just going to rely on that.
Right, and they said that they were satisfied that Mr. COMBEE was rehabilitated, but they didn't authenticate any of their documents, and yet they were saying that they were relying on...
Well, I noticed it was quite interesting that the trial judge, has he been rehabilitated? Oh, yes, he's been sober since 1984, but there's something in the record indicating that his license was suspended again in 86 for 6 months because he refused to take a breath test. Well, or was it 88? I found that quite
Your
interesting.
Honor, 1988 was when his license was restored, and he hasn't had no offenses since.
No, there's. I can tell you right now on his driving record, there is a 6-month suspension. I believe in 86 or 88 for failure to submit to an authorized breath test.
Yes.
So, I mean, I found it very interesting that it was represented. Oh, he's sober. He's been sober for all this time, and then in 86 or 88, he gets another 6-month suspension because he refused to take the breath test.
This is very important, and I state this to this court because the judge asked me about that, and I did make that representation, and I made that representation that he had not had such an offense since
I'm not saying-
September of 1988 was when
Okay.
his license was
Okay.
reinstated.
I'm not in any way suggesting you made any misrepresentation.
All I'm saying is after
Okay.
that, after his license was reinstated in
So you told the trial judge
1988.
about that in 88, okay, all right. Okay, I got you.
I very much appreciate the court's attention.
All right, thank you.
so much.
I only have a few points to make.
What about he says that in 84, when it was revoked for life, that he was eligible 10 years later for a license.
Judge, I don't know the exact state of the law of what all the changes have been, whether he could have gotten a full
Well, if
license
that's the
after 10
case,
years.
then why wouldn't what the trial judge did have been appropriate, just to order that his license, instead of 2006, maybe to go back to 10 years after.
Well,
I mean,
certainly.
he was entitled to a license, according to what he says under the law. And I don't know what the statute says.
Well, certainly,
10 years later, I mean, he was entitled
If
to.
in 1994, he had been, assuming that the law in 1994 said that you could get that, which I don't believe that it did, but assuming that in 1984 when he pled, maybe there was a position that after 10 years you could get that, but the law has changed numerous times, as even counsel's indicated.
Yeah.
Over the years, they've taken it away, they've modified it. Whatever would be in place when he goes to get the new license is the law that it attaches. It's not a vested right that he got in 1984 to reapply after 10 years. It's what existed in 1994. And my understanding of the law is that at that time, a hardship permit would have been the only thing he would have been entitled to get.
Your position is that you have to look at what the state of the law was in 2007?
At this point, yes.
What about the argument that it was an illegal revocation to revoke it for life as opposed to permanently revoked it?
I'm fairly familiar with the case. I don't have it I'm not prepared to give it to the court today, but I'm not aware of any court case, appellate or otherwise, that makes a distinction between a permanent revocation or a revocation for life. Certainly, I think the statute is self-executing. We keep talking about it's not. I think the cases are also clear that it is self-executing. The actions we're talking about, the court shall, or if the court fails to, the department shall, are ministerial acts. It's something where we're putting into place the statute. The license is not going to suspend itself because the statute says to do it. Someone has to take an act, and the statute is directing the court, and if the court doesn't, the department to take this act and make sure that this is implemented.
Okay, well, back in 1984, after the judge suspended it for life, the DMV canceled or suspended it for 1 year.
My understanding is the department was notified that it was a first DUI, is why it was issued as a 1-year suspension. I don't know what the...
By whom?
my understanding is by the clerk.
I'm sorry?
By the clerk. When we got the paperwork, it was issued as a first DUI.
Did you not look at the language about being suspended for life?
I don't know the
Not
answer
you.
to that question. I don't know if they did.
Is that order in the record?
I don't know that order is. The order from his DUI conviction in 1984, I don't know that order's in the record. I would also point out, I don't think that the issue of notice of a suspension is the same thing as suspension goes into place. Certainly, if the department sends notice of that suspension and puts it on the driving record, a person's presumed to have notice. I don't think that affects the validity of the suspension. It would affect their knowledge of that suspension, so if they're ultimately arrested, we would have, it would be almost impossible to prove knowledge of it for driving under a suspended license. But to me, the sending of notice doesn't affect the validity of the suspension, just whether a person is on notice that their license is suspended ultimately for driving later. If there are no further questions,
I have one more. If the department suspends your license for a year, after that year is up, does the department send you some sort of notification about how you go about reapplying or I'm not using perhaps the right language, but reactivating your license?
Generally speaking, no, I don't believe they do. If you have a suspension, normally there is an act. I mean, some suspensions are time executing, that when the time frame passes, you can go down to DMV and just say, I want my license back. They'll check and see that the time period has passed, and they'll reissue you a license upon paying of a reissuance fee.
Okay, but you don't send, the department doesn't send out an affirmative notification.
No, I don't believe that we send out a notification telling them how to do it. In other cases, like in a DUI revocation, there are certain conditions that must be met. So even after a year had passed, a person would have to comply with the DUI school and certainly some other conditions before the license would be reissued, regardless of the amount of time, whether they serve the time period suspension or not. All right. Thank you.
Hey, Mr. Hatfield, is it in, you said you found the order, just, is it in the record or not? Just, you can
If
just-
it please the court, Your Honor, it's attached to my complaint as Exhibit A. It's referred to as the order revoking the license for life.
okay, that's, so your complaint is Exhibit A?
Yes, sir.
Okay, thank you all very much.
Thank you.
Okay.